I'm Matt O'Connor. I'm an attorney in Kansas City, Missouri at the O'Connor Law Firm PC. I've been practicing law for 20 years here in the state of Missouri. I'm also licensed in the state of Colorado. Oftentimes people ask me what is a deposition and what are some things you should know before having your deposition taken. Well, first of all, answer the first question, what is a deposition? A deposition is nothing more than an opportunity for the opposing side to take your statement. That sounds very simple, but here's how the process works. A court reporter is hired, an independent court reporter that doesn't work for either lawyer, to take down everything that is said. It's called being on the record. For example, maybe if a break comes up, the court reporter might say, is this off the record, is this on the record? Or the attorney might say, this is off the record, and say, okay, we're going to take a 15-minute break. So everything the attorney says in the deposition, every question they ask you, and every answer you give is taken down and put in printed form. That's why you see the court reporter's fingers moving very quickly, or oftentimes they also use what's called like a mouthpiece where they repeat what is said and then later transcribe it. Once the deposition is taken, you will have the opportunity to make grammatical changes. You really can't change a lot of the substance of the deposition, but again, that's probably something you need to ask your lawyer about in order to determine what you can and can't change afterwards. But normally, to be on the safe side, I would advise you that you can't make major changes to what your testimony is, because that's exactly what a deposition is. It's an opportunity for the lawyers to ask you questions while you're under oath to find out what you will testify to when the case goes to trial. I often tell people, and it's true, there are no trick questions. I want to find out everything you know that's possibly related to the case. And there are a lot of times we have to go into annoying lawyer detail. We'll go into all the residencies you've lived at, if it's a personal injury case, the doctors you've seen, the ailments you've had. If it's a divorce case, we might review all of the assets that you have, any properties you've owned, any partnerships you've been involved with, the nature of any credit card charges as it relates to marital debt. So those things can be excruciatingly boring and very detailed. So here's some tips to keep in mind when you're having your deposition taken. Number one, listen to the question. I oftentimes, it's probably a pet peeve of mine, given the nature of my profession, find that people don't listen to the whole question. So it's not really a trick, some advice I would give you about your deposition is to give yourself a 3-second time delay. Think about the question they're asking. If they ask you what time it is, don't tell them how to build a clock. For example, if they ask you, let's say it's a divorce case, when did you meet a certain person? Answer the question only. Don't tell them how you met them, why you met them, or what you did when you met them. Just tell them when. Give them a date. Less is more. And the other thing that I always tell people, whether they're my client or the person that I'm deposing, is don't be afraid to inquire of the inquirer. That is, if the question is vague, or you're not sure of it in your own mind, don't answer the question. Ask a question back. So if I ask you, how many blue shirts do you have? And you're thinking, I wonder if he means short sleeve or long sleeve. Ask it. You can restrict the scope of the question by inquiring of the inquirer. The other thing that is very important to understand is how you say something will not come across in a deposition. So sarcasm, not a good idea. Oh yeah, I killed the guy. That's inflection, but it's going to read on paper, oh yeah, I killed the guy. So be aware of how you say things that doesn't translate into deposition transcripts. And most importantly, don't be afraid to take a break. If you feel like you're getting confused or fatigued, say, I need to take a break. If you need to use the restroom, have a glass of water, or just clear your head for a moment, you are entitled to do so. And your lawyer will probably tell you that as well. Keep that in mind. These can be long. In my opinion, I think depositions tend to be too long. I think they can be nearly abusive. The idea behind a deposition is so that each side can discover what information a particular witness has. And having it go on for 2 days is abusive, in my opinion. If you can't find out what you need to know in 4 hours, then you're not asking the right questions, or you're on a fishing expedition. And that's a phrase, if you Google it, fishing expedition. Depositions are not supposed to be like that. They're not supposed to be where we just ask about any willy-nilly question, try to find out something we didn't know, or things that may not be related to the case. A good reminder for lawyers, for law students, and for people who are going through litigation, there has to be some connection to what the case is about. It's called relevance. You've probably heard that phrase many, many times. Is it relevant? And relevance in the law generally means, does it tend to prove or disprove a fact in controversy? If you're being accused of rear-ending someone, the fact that you picked your nose in 2004, does that have any relevance to proving or disproving that particular fact? If you're in a divorce, what you did in college, does that have anything to do with whether or not you're a fit father, or whether or not how marital assets should be distributed? No. And if your attorney is sitting there with their thumbs up your you-know-what, feel free to take a break and ask them. I'm not a lawyer, but is this relevant? The questions they keep asking me, do I have to answer? Now, there's a couple of rules you need to understand about that. You cannot generally refuse to answer a question unless it touches upon two basic areas of law, and that is if it's something that tends to incriminate you. For example, if they ask you whether or not you stole the Hope Diamond, you don't have to answer that question. Or things that could relate to income tax evasion, you don't have to answer those. The rest of them you do. And the reason you want to go back to that 3-second time delay, at least, it's not only to give yourself time to make sure you understand the specific question that's being asked and answer that question only, but it's also to give your lawyer a chance to object. And most of the time you'll hear him say things like, object to the form of the question, object that this is beyond the scope of discovery, things of that nature. So you want to give your lawyer a chance to answer the question. Then the lawyer will often say, you can go ahead and answer. Now, what happens with that transcript that we've talked about is that the lawyers will then argue in court, because that's what we do. We argue for a living. They'll go into court with the judge and say, Judge, on page 45 on line 12, I asked the following question and the opposing counsel objected. And then the judge will rule or not whether the question and answer can be used at trial. The best thing to keep in mind is there is one person in the room that knows the truth. One person in the room who is testifying. It's your story. These are your facts. Don't let anybody trick you, and realize that telling the truth is always the best idea when you're under oath. Because not telling the truth can really blow up on you when you're testifying in open court in front of a jury. And here's why. Because the jurors will see that you gave a prior inconsistent statement while under oath. For example, if I say the car was blue in my deposition, and then I go into court and say the car was red, then the other lawyer could bring out my sworn testimony and say, well, Mr. O'Connor, is it true that on such and such date you swore under oath the car was blue? That's called impeaching the witness. So that is why you want to be particularly careful about what answers you give. And if you don't know the answer to a question, don't guess. Don't make it up. If you're not sure, say you're not sure. If there's a document that would help refresh your recollection, ask for it. No one expects you to know like in a personal injury case, every time you went to the doctor, if you had a back injury, or if you had a broken leg, or the exact time. What you can say is, well, if I saw the medical records, that would refresh my recollection. And what documents can be used to refresh your recollection? Anything that helps you remember. It could be a ham sandwich. If that helps you remember what day you went to the doctor and what you were treated for, that's something you can use to refresh your recollection. The most important thing is make sure that you take the time to talk to your lawyer before the deposition, not the morning of the deposition, at least a week in advance or a couple of days in advance, so you understand the purpose of the deposition, what the goals of the deposition are, and so you know what to expect and can look back and prepare. One other tip before we conclude. If your state, or if your jurisdiction, or if in your case more specifically, allows for interrogatories, which are written questions in written answers. Then you want to make sure that you review your prior written answers so that you can make sure that your testimony is consistent. And don't be afraid to have a copy of them there if you need to look at it. But again, check with your lawyer before you do that. You should always rely on your own lawyer's advice because that lawyer is particularly suited for your case and knows the facts better than me being general here, giving this educational video. And that is what a deposition is and what to do and what not to do in a deposition. I'm Matt O'Connor with the O'Connor Law Firm in Kansas City, Missouri.